Okay, welcome back. This is the last of the four slides dealing with privacy and the constitutional issues and history behind that. All right, so we're going to take a look at the Hirabayashi case. I believe I asked you to read about this. This is, like Korematsu, a case that dealt with a suspect classification of alienage. So this has to do with the internment camp of Japanese Americans after the bombing of Pearl Harbor. So Gordon Hirabayashi was a man, as you read, who was under curfew. So after a certain time of the day, Japanese Americans or Americans of Japanese descent had to not be on the streets. This is a time of war, of maybe even some hysteria and panic, and so it raises. What's interesting is this man conscientiously decided to break that curfew, to challenge the constitutionality of that. Now, just imagine that, what that's like. You know, it's a time of war. People that look like you are the ones that are being targeted, and here he voluntarily, as an American citizen, acting on his own volition, decides to challenge that by putting himself at risk. So he was arrested, and again, he was one of 70,000 or so Americans that either were put in internment camps or were whose rights were restricted at this time. It was an executive order. And so what happened, of course, was he challenged this case and lost. The Supreme Court in 1943, as a precursor to Korematsu, was trying to test the constitutionality of this. And the discrimination issue before the Supreme Court was a different issue. And so what they were looking at was the constitutional right of privacy, or the right to move about freely. And they said in a time of war, all bets are off, basically, which is a slightly disturbing signal. So this is a unanimous decision against him. And some of the Supreme Court justices that voted against him, I think maybe were a little surprised at what would have happened if this had been continued to be applied in other cases. And so I think that's why there was at least a dissenting opinion in Korematsu after that. Anyway, so here's Gordon Hirabayashi. An interesting little note: he was a Quaker. So as you know, these were Anabaptists who have a very, very strong sense of conscientiousness. And for our entire history, we've had a status for conscientious objectors to war, people who, on religious or ideological grounds, feel that it's a violation of their rights, either as religious practitioners or just as citizens, for serving or supporting certain actions by the military that violate their religious principles. And so he's written on his little card there on the side in handwriting, says, "I'm a conscientious objector." He was later put into jail for a hard time for a year in federal prison. Interestingly enough, the war effort was so threadbare at this time, the government could not afford to transport him to the prison. So he had to hitchhike to the prison. He did that voluntarily and served his year. So we'll move on. So we get to another issue, again, dealing with the government, with presidents, and what applies to them in terms of privacy. So does a president have a right to privacy? Is he or she different from anyone else, a citizen or resident? Does the Constitution protect them? Well, yes and no. And so one of the things that came to a head, to make a very long, complicated story short, had to do with Richard Nixon, President Richard Nixon, which eventually came to the Supreme Court. And so, all right, so Nixon had been recording telephone conversations that happened in his residence in the White House. As a public servant, but also as a private citizen, he felt he had the right to do that. And so when he was under investigation, he was ordered to hand those over. and withheld them. And so the Supreme Court eventually had to deal with this, or they didn't have to, but they did. So the question before them in 74 was, can federal courts order a president to surrender materials wished to be kept private under the protection of this concept of executive privilege? There's nothing in the Constitution that says executive privilege, but there's a common law belief that some leaders might have different standards, constitutional standards. And so in this particular case, the court said, yes, they can be ordered to surrender materials. Why? And the reasoning goes like this. You can look at it for yourself. But basically, the president does not have absolute power over their own privacy, especially with an investigation or subpoenaed materials. And I'm simplifying this, of course. There's a lot to it. But basically, that was the thrust of their argument, that they're not different from other people when it comes to that. There are some tweaks to that. But they said, principle is the president is sworn to uphold, not abuse the Constitution. And that means not abusing the due process either, even if they are the ones that are under investigation. Remember the Hamilton-Madison debate about some philosophies say that the president can do anything that he's not restricted to by the Constitution, and others say they can only do what's delineated to them in the Constitution. And I need to point out that President Trump has been involved in many lawsuits. This one in particular has gone all the way to the Supreme Court, and this is about revealing his tax records. This was supposed to be argued orally before the Supreme Court this week, and because of the pandemic, it's been postponed. So they might hear this later in the term. They might hear it next term. We're not quite sure. So it does raise a good question. Must presidents divulge their tax records, or is that private information? So that remains to be seen, I think, at the moment. Then we turn to other issues, radically different here. Bowers versus Hardwick, which was a very important case. It was the leading case up until years ago when I was teaching this course. Literally, as I was teaching the course, there's another case that came down that dealt with this, that challenged Bowers versus Hardwick. But basically what happened is, so an investigator was investigating someone's home. They came in, they witnessed two men having gay sex, an act known as sodomy, and arrested them based on that. So in Texas, where this happened, there was a law, as there were in many states, prohibiting that, even in the privacy of one's home. So these officers were there, they noticed it, and arrested them. So eventually it was challenged and went all the way to the Supreme Court. And again, this has great ramifications for privacy in the home, right? In terms of sexuality. And the Supreme Court basically voted against that notion of privacy. But why? Here's what I believe it was Rehnquist at the time argued himself. He said, this is not rooted, allowing sodomy to happen even in someone's home is not rooted in our nation's history or tradition. All 13 colonies had sodomy laws, anti-sodomy laws. All 50 states had sodomy laws until 1961. He said it's just not our tradition. Nothing has supported this in terms of our legal history. There's no specific support in the Constitution for gay sex, even in the privacy of one's home. Otherwise, illegal conduct does not immediately become immunized if it occurs in privacy of home. So it's not, even if it's considered a victimless crime, it does not mean that it can't be restricted. Rehnquist goes on to say that an opposite decision would invalidate the laws of most states at the time in 1986. So an interesting, pretty strong take on that. That very issue was challenged later, several years later, by Lawrence versus Texas. So it's important for a number of reasons. One is that it's also in Texas. Also, it deals with the same basic facts of the case, the same principles, but so much had changed in just that, 2 decades. So does that statute in Texas, and by presumption the other states, that makes a same-sex act criminal? Does that violate the Constitution? And the Supreme Court in 2003 said yes. They totally overturned Bowers. They said the Constitution allows homosexuals to enter into sexual relationships. So what has changed? It's not the facts, really. It's how we look at the Constitution and how it applies to everyday life, right? They went on to say that logic used in Bowers, based in ancient anti-sodomy laws that protected against predatory but not adult consensual sex. So basically it was saying that Rehnquist was a misreading of how those the intent of those laws. It's to protect people, not to prevent consensual adults from entering into that kind of sex, especially in the privacy of their own homes. It does not withstand constitutional scrutiny pertaining to discrimination either. It seems to it seems to focus on a particular group, which is also a suspect classification. So tremendous ramifications in regards to sexuality. And then last but not least, we get to Griswold versus Connecticut, which is really interesting because I thought about starting with the slide and prefacing the Bowers and Lawrence by this. But one of the things that was argued in the Lawrence case was this had to do with the Griswold case, which I started the whole privacy unit referencing. So Griswold versus Connecticut is an interesting case that deals with laws that prevented people from getting information about birth control, right? So for about 100 years, about 90 years since President Grant's administration, had people who wanted to find information about birth control found that they couldn't do that because this was considered obscene information. So if you have a right to your own reproductive system, it seems to stand to reason that you should be able to get information about that reproductive system, but people were being prevented from doing that. And so that came to a head with a landmark case, Griswold versus Connecticut, that prohibited any, quote, drug, medical, article, or instrument preventing contraception. According to the law, those who assist in informing people are as guilty as the offender. So what the Supreme Court was really deciding here is, does the statute prohibiting the assistance of an abortion violate the Constitution, or getting information about an abortion? Does that violate the Constitution and reproductive rights and what information is available? Just getting the information. In that particular case, they said yes. So, but the important takeaway is this: the thing that I want you to consider about, without getting into the controversies about abortion, is the idea of privacy. So privacy over one's body, in this case, is linked with the freedom to acquire information about that body. So that might strike you as kind of an interesting sort of roundabout way of dealing with privacy. Nonetheless, one of the interesting things to me about this is how, for one of the few times up until this time in which the Ninth Amendment about quote-unquote natural rights was invoked. So what they said is, in the majority opinion, they talked about the right, one of the natural rights is to reproduction and information about reproduction and contraception. And also, they kind of mention this, the glittering generalities, quote unquote, about this. Like, if you just say anything's a natural right, that could open the floodgates to any number of things, and that can be a concern. Nonetheless, it's Griswold which came up with the idea of that penumbra, right? The privacy is implied, but it's not explicit in the Constitution. Oh, there we are. And because of this interesting, important case in 1965, what came of that is in 1973, this was eventually used in Roe versus Wade, which allowed for abortions. In 1977, that 16-year-olds can get information about contraception. In 2003, that homosexuals can engage in homosexual relations, because that's a penumbra. And then in 2015, that people of the same sex have a right to marry, because of this idea of the natural rights of the Ninth Amendment and this penumbra of privacy. So that's it, folks. That's the last slide of privacy. Hopefully this piques your interest and gives you a good sense of that boundary we were talking about between private and public, and what the Constitution has said, and says now. Thank you very much.